Hello, class. Again, welcome to this course. For this semester, we will be talking about the law on obligations and contracts. But what exactly is law? Etymologically, law was derived from the Old English word lagu, which means something laid down or fixed. It is, however, difficult to give a precise definition of the word law. As one eminent jurist said, we find in all human sciences that those ideas which seem to be most simple are really the most difficult to grasp with certainty and expressed with accuracy. The word law is used to describe properties, relations, or conditions existing everywhere in the physical, mental, and moral world, in the exact sciences as well as in the mental and moral. Having defined law, let us now look at the classifications of law. There are two general classifications of law. They are jural or human law and non-jural or meta-legal law. Jural or human law refers to sanctioned or enacted law such as statutes, case laws, normative rules, and precepts. Non-jural or meta-legal law refers to laws that are not anchored on human promulgation, such as divine law, natural law, and physical law. Divine law is that law that proceeds from sacred writings such as the Bible or the Quran, backed up by faith. Natural law is the law of our human nature based on the demands of our humanity. Natural law suggests that human laws are derived from eternal and unchangeable principles found in nature, and people can become aware of these laws by the use of reason. Examples of natural law includes 1. Parents should care for their children. 2. One should try to preserve one's life. 3. People should do no harm to others. 4. We should help the vulnerable and disadvantaged. And last one is the physical law, which refers to the mechanical laws of the universe. Examples are the laws of gravity by Galileo or the Newtonian mechanics or Einstein's law of relativity. Non-jural laws are the concerns of theologians, scientists, and physicists. As students of obligations and contracts, we will obviously be dealing with jural law. It is in this sense that we ask, what is law? In one case, the Supreme Court, citing the renowned civilist Sanchez Roman, said that law is a rule of conduct, just, obligatory, formulated by legitimate power for common observance and benefit. The above definition echo Thomas Aquinas' explanation that law is an ordinance of reason ordered towards the common good, promulgated by him who has charge of the community. So, having this definition, we now move on to the characteristics of law. The first characteristics of law is that it is a rule of conduct. Law tells us what shall be done and what shall not be done. As a rule of human conduct, law takes cognizance of external acts only. Law is a rule of human acts, commanding man to act or refrain from acting. The measure of human act is human reason, for it is by reason that we perceive and put order into things. A reasonable law is necessary, useful, clear in expression, and adapted to place and time. The people are moved to follow the law when it is reasonable. If the law is unreasonable, it would only invite defiance and dissent. The next characteristic of law is that it is obligatory. Law is considered a positive command imposing a duty to obey and involving a sanction which forces obedience. And the third characteristics, it is promulgated by legitimate authority. In a democratic country like the Philippines, the legitimate or competent authority is the legislature. Under the Constitution, laws are enacted by Congress, which is the name of the legislative branch of our government. Due promulgation must come from a competent authority, not from some private individual or public official unauthorized to enact a law. Law must be issued by one who takes charge of the community, who wields the power to promote the common interest. And the fourth characteristic is that it is of common observance and benefit. Law is intended by man to serve man. It regulates the relations of men to maintain harmony in society and to make order and coexistence possible. Law must therefore be observed by all for the benefit of all. The common good need not be the utilitarian ethics of the greatest happiness for the greatest number. Rather, it is the good of everyone. It bears the common aspirations of all, not just the majority. Still, majoritarianism argues that although the majority opinion can be fallible, it is still the best way to arrive at the most reasonable terms, as more heads are better than one. That there is more intelligence, experience, and wisdom in number. We should be careful, though, to distinguish popular morality or popular good from the common public good. A law can be a valid public order, reasonable and fair to all, although it may be unpopular to many. Having identified the characteristics of law, we are now ready to move on to the sources of Philippine laws. So, what are the sources of Philippine laws? The principal sources of law in the Philippines are the Constitution, legislation, administrative rules and regulations, judicial decisions, and customs. First, the Constitution. The Constitution is often referred to as the fundamental law or supreme law or highest law of the land. It is promulgated by the people themselves, binding on all individual citizens and all agencies of the government. It is the law to which all other laws enacted by the legislature must conform. This means that laws which are declared by the courts to be inconsistent with the Constitution shall be void, and the latter shall govern. Second is the legislation. Legislation consists in the declaration of legal rules by a competent authority. It is the preponderant source of law in the Philippines. Acts passed by the legislature are so-called enacted law or statute law. Legislation includes ordinance enacted by local governments. So, that ordinance that was enacted by your barangay captain together with the lupon or the kagawads is an example of a legislation. Third is the administrative or executive orders, regulations, and rulings. They are those issued by administrative officials under legislative authority. Administrative rules and regulations are intended to clarify or explain the law and carry into effect its general provisions. Administrative acts are valid only when they are not contrary to the laws and constitution. Fourth, judicial decisions or jurisprudence. The decisions of the courts, particularly the Supreme Court, applying or interpreting the laws of the Constitution, form part of the legal system of the Philippines. And this is in accordance with Article 8 of the Civil Code. And the fifth source of law is the customs. It consists of those habits and practices which, through long and uninterrupted usage, have become acknowledged and approved by the society as binding rules of conduct. It has the force of law when recognized and enforced by the state. Other sources of law includes principles of justice and equity, decisions of foreign tribunals, opinions of text writers, and religion. They are, however, only supplementary, that is, they are resorted to by the courts in the absence of all the other sources. So, we are now ready to tackle the law on obligations and contracts. When we speak of the law on obligations and contracts, we refer to the body of rules which deals with the nature and sources of obligations and the rights and duties arising from agreements and the particular contracts. The law on obligations and contracts is found in Republic Act number 386, otherwise known as the Civil Code of the Philippines. When we speak of civil law, we refer to the law found primarily in our civil code. The Civil Code of the Philippines is based mainly on the Civil Code of Spain, which took effect in the Philippines on December 7, 1889. It was approved as Republic Act number 386 on June 18, 1949 and took effect on August 30, 1950. The Civil Code is divided into 4 books. Book 4 deals with obligations and contracts. The general provisions on obligations are contained in Title 1, Articles 1156 to 1304, while those on contracts in Title 2, Articles 1305 to 1422. So class, this ends the introduction on the law on obligations and contracts. Feel free to post your questions if there are points that are not clear to you. See you in the next lesson.